Hello, good evening, Devanshu sir.
Good evening, Gauri.
Good evening, sir.
How are you?
Fine, sir. How are you?
I'm fine. I hope I'm audible and visible as well.
Yes, sir.
I
Sir,
quickly
yes, sir.
test the PPT once, है ना? Just give me a second.
Sure, sir.
I hope the PPT is visible.
Yes, sir. It's visible.
Also, Gauri ma'am, just help me whether you can see the slides getting being changed.
Yes.
Perfect.
So, sir, shall we wait for a few more
Yeah,
minutes?
we can wait for 5 minutes. है ना? I'll wait for your final get to go, then we can start.
Sure, sir. Sure.
Okay.
Yes, sir. Shall we start, sir?
Yes, ma'am, good to go.
Okay, sir. So, good evening, everyone. Welcome to the day 4 of the National Level Workshop, come 1 week faculty development program organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Padan Mohan Malviya National Mission on Teachers and Training, Ministry of Education, Government of India, powered by Droid Panel Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj. So today on day 4, we have with us Dr. Devanshu Srivastav, Head, Faculty of Law, Jagran Lake City University, Bhopal. He is our resource person for today. And the topic for today is Intellectual Property Rights, day 2. So welcome, sir. You may proceed with the session now.
Thank you so much, Gauri ma'am. And I really hope the participants are really enjoying this faculty development program. As I'll be continuing to what was taught or what was shared yesterday, this 2 hours that have been dedicated or given to me by the organizers, I'll try to put across certain points which might be a repetition of what was taken yesterday by Professor Nayak, or there might be some new additions to it as well. So I'll just take an apology beforehand itself if there is something repetition or two. Also, I would appreciate that the usage of the chat box, I hope that is activated for the participants to take that thing ahead. So we can take it in any sort of the doubts or any of the questions that the participants have during the session as well. So a very warm good afternoon from the northern and the central part of India to all our participants. And as the organizers have informed me that we have participants across the country and various states of the country and union territories being participating on too. The intellectual property rights primer is something that I still believe myself to be a student of. Being someone who was teaching IPR is just by the matter of the fact that I did my master's in intellectual property rights and so my doctoral studies as well. But I still believe myself to be a student of intellectual property rights. A domain which is, I am still unsure, and so is the history on that since when this particular intellectual property rights came into existence. Yes, the earlier format was different in relation to how the industrial property was there and how the movement from industrial property to the intellectual property took place. Not only that, the role of international instruments, particularly like that of the TRIPS, and the role of the international institutions like that of WIPO is something that would be dealt in detail and also in the very simple way as the participants are from across various domains. I would appreciate if the chat box is being utilized or any unmuting process is there for the particular questions. Be patient so that we can take it ahead smoothly and simultaneously. So intellectual property rights and how is the impact. I was also informed that the session yesterday majorly covered the intellectual property rights. So we'll try to take it ahead also. So moving next is how the intellectual property rights and what are the things. So we'll first start what are the law governing the IP. Now, when I say law governing the IP, I only do not limit myself to the legal participants or the participants from legal background here. But this is a major step I would take, that how and the purpose of defining it as one of my first or foremost slides is that we should be very much aware of how the intellectual property rights is systematized. Now that is where international roles like TRIPS played, which not only transformed or characterized the intellectual property rights into various domains, but it also led a universalization of the intellectual property rights. What I mean by the universalization, the next couple of slides would be very much or in detail, would like to enhance that particular meaning. The second and the point, which I guess is the basic thing why such faculty development programs have been organized. I would compliment my organizers, not only for inviting me to take one of these sessions on the intellectual property rights, but also the variety on the 4 domains that they chose are something which is predominantly very much required in the society today. So that meaning of the intellectual property rights and what are various intellectual property rights which has been included. IPR is nothing but a bundle of rights. We might have heard that statement yesterday. You will hear that statement again and again whenever the term intellectual property rights comes into play. The third is the types of the intellectual property that we deal on to, where we includes the patent, the trademark, and the copyright. So these are the major of the, not only the kinds or the types of the intellectual properties, but also the protection which is given under the intellectual property rights regime. So as a matter of right, if I am claiming certain of the intellectual property, this is how I would be taking also, or what would be granted to me. The fourth topic or the fourth section of this presentation in the next 1.5 hours would cover the infringement part as well. Now, when I speak on the infringement, I really mean the infringement of the top three that we see out here is the patents, the trademarks, and the copyright. So how an infringement is made, what would be the recourse of that infringement, and how a person who owns that intellectual property right claims in case or behaves in that case of an infringement of the intellectual property rights. The second last topic of the presentation deals with the case studies. And finally, when we come on to the conclusion, here the conclusion would not be of a topic because, as I said, this is one domain which is evolving each day and can never be possible to conclude it into a 2-hour session. Not only that, I would utilize this last section more towards an interactive session where my participants can take it. I have also opened the doors during the presentation as well, where we can take such questions and or any of the valuable suggestions or something. I, as a student of intellectual property right, would always be open for the same. Now, before I move towards the intellectual property, we need to know the international organization that has been working on it. These 4 alphabets on your screen is nothing but the entire sum up of the agency or the institution that is taking care of intellectual property rights. Yes, I'm talking about WIPO. WIPO, which stands for World Intellectual Property Rights Organization, is an international body which was established by the WIPO Convention in 1967. It is a specialized agency of United Nations. All my dear friends of political science, public policy, and legal studies would definitely know what are the organs and what are the specialized agencies. So WIPO stands as a specialized agencies of the United Nations. And as the word itself suggests, this is nothing but an institution which governs or promotes and protects the intellectual property rights. I use 3 specific terms: governs, protects, and promotes. Now, governing means all the laws, regulations, the protection, tenure, and other such things would be taken care by WIPO. Second, for the protection of the intellectual property right, protection that at a stage, because when we say that intellectual property rights are nothing but the institutional rights, or they are also termed as a lex loci, that is the law of the land, which means that if it is an intellectual property right of India, it would be protected within the transboundaries of India. And that is where agencies like WIPO comes into handy to take care that it should not only be limited towards a territory, but something when it is at a gross stage is being violated and countries have come across. I'd like to cite one wonderful example here is in the case of the Basmati patents. Now, in this particular case, and this is very few of those examples where India and Pakistan together have come on a stage and they have togetherly filed an infringement patent application against the US, where Basmati rice was being patented. And this is where WIPO took an objection was filed jointly by India and Pakistan, and WIPO took a cognizance of it. Not only that, what I also want to tell that if we closely observe this particular logo of the WIPO here, which is, I am referring to the left corner top side of the screen that is visible. This WIPO, as you see in the inner circle, there are two big circles as we can see. The inner circle mentions the name of the WIPO, that is the World Intellectual Property Organization. But in between the bigger circle and the smaller circle lies 5 specific things, where are the 4 of them clearly resembles of how the intellectual property rights are being taken on. And if I start it in the clockwise direction, starting first with the emblem, which includes a hand and a pen, that refers to how a protection of something can be taken. Now, this particular image, if somebody would tell you that this is nothing but resembling a copyright, I would disagree a bit. But yes, majorly they can also be right, because whatever a person is intending to write with a pen or a person is intending to draw with a pen is nothing but a subject matter of copyright. The second comes, as you can see, it's a part of a machine which can be used for multiple purposes, and this is nothing but what can be protected under a Patents Act as well. And then on moving ahead in the clockwise direction, the number 3 that I'm referring on to is nothing but, you can see, a book in that particular format. A book or a service manual, as we can broadly classify this. This is a perspective that can be copyrighted or can be trademarked as well. Then moving ahead is the 4th figure, as I'm referring on to, is how, and this is nothing but a part of a farm produce. This is basically, if you see it in the form, it can be dhan or a gehu ki bali, as we can call it in the local dialect. And what it is trying to reflect is a new addition to the protection, that is the protection of the farmer variety or the breeder's right. The next ahead, as we can see, is nothing but how a particular instrument's handle can be seen in that particular form, which is also nothing but how a design of a particular instrument takes place. As you all can see, this is nothing but a reflection of how a sitar or a guitar or certain, or that can be used in the form of any machine part, can be taken. This 5th figure is representing the form of the design that we can see on it. So as overall, if we can see this entire logo here, this is nothing but all the types of the intellectual property rights which the World Intellectual Property Right Organization not only promotes, protects, or also governs. Now, the headquarters of WIPO is in Geneva, Switzerland. Every year, April 26th is celebrated as World Intellectual Property Rights Day. Intellectual Property Rights Day comes with a perspective of why this particular day was chosen by the WIPO, was because the Geneva Convention or the WIPO Convention came into place with the same thing. Who are your favorite visionary innovators? You can get across how the events have been done. The WIPO's birthday in the year 1967 has been taken, and how the Intellectual Property Rights Day would be taken into vision. Now, intellectual property rights in India is nothing but an expansion as to what I was referring on to, the universalization of the intellectual property rights. And that is how the role played by the World Intellectual Property Right Organization comes into play. Now, there are many big or small intellectual property law firms, including like that of India, US, UK, Chicago, etc., providing qualitative help to the investors and creators to the protect. Now, this particular inventor or of a product is being protected in that particular country. In India, intellectual property rights are safely protected and controlled by well-established statutory and judicial framework. This well-established statutory and judicial framework, as I'm referring on to, is not as to claim it to be a legal right, but a right so that that can be protected and written in very well format in a form of a particular provision to be taken out. Apart from that, there are many attorneys and law firms of IPRs in India in various states. So in India, if I could define, there are at present nearly 1,348 registered intellectual property law firms or the property right firms existing as per the website, the IP India website, which is a government mandated website to be dedicatedly in the fields of an intellectual property right. This is to be today's morning data. Now, what is intellectual or property and what is it basically its meaning onto? Intellectual property arises from the human intellect. And that is how it first, or the combination of three words, intellectual property and rights. This intellectual or the intellect comes from this particular word itself. It is a product of human creation. Now, why I'm saying this is a product of human creation? Because on this planet Earth, the planet green Earth, our Mother Earth, consists of floras, faunas, and varieties of animals as well. But it is only the humans who have, I'll not say that the other species or the other animals or other things, they don't have an intellect. But the idea of expression of an intellect, and that intellect needs to be protected legally as a matter of right, can only be done by a human. And that is also where the intellectual property right comes into play. So intellectual property comprises of two distinct forms. Earlier, it used to be termed as industrial property, and today we see it to be an intellectual property. Now, what was the major difference? And this was way too long, coming by 1996. So what was the major difference between industrial property and intellectual property? Industrial property was everything of what today's intellectual property is, except the copyright. So if I come across with a formula, I would say intellectual property right is equal to industrial property plus your copyrights. And this is what, when I say the copyright, I mean the literary and the artistic work plus the industrial property. And when I say the industrial property, it is further classified into patents, trademarks, designs, and how and what other formats that we see. Now, what is this literary and artistic work consisting of? Literary means something which is in the format or has a value to be taken into the form of literary, which will include books, paintings, musical compositions, plays, movies, radio, TV programs, performances, and other artistic works as well. Now, when I'm talking about the books, this includes without any limitation, prose and poetry. This includes a novel, which can be a sci-fi, which can be a thriller, which can be a romantic, which can be of any domain. It also may include a book which is used by a student in class 12th or class 10th or even in nursery. This may also include a book which only has pictures or caricatures and nothing written in the format of it. Paintings in any format. It can be a crayon painting, it can be a pencil painting, it can be an oil painting, it can be a mosaic painting, it can be a painting which also is a 3D painting. It can be just any form of the art that is painted. Painted by colors, painted by charcoal, painted by anything that you can think of too, is a product for copyright itself. Next is a musical composition. And musical composition, irrespective of any particular fact, would consist of either jazz, pop, or rock, or any such composition that we take on to. Next is moving ahead, consists of movies. Now, this movies, as we can say, is nothing but in a format that how those particular things can be taken into consideration. Taking into consideration means that these may include even a silent movie. This may include a dumb smash. This may include TikTok. This may include Snapchats, what and howsoever you think of it. Next is a radio or a TV program, which also now includes OTT platform or the over-the-top platforms as well. Performances and artistic works, this can be live, this can be recorded. This can be in any feature that we can seek on. Now, how and how they are protected? They are protected by the copyright. So as I was referring in the previous slide, intellectual property rights are nothing but the combination of industrial property plus a copyright work. So we understand that this literary and artistic work that we are referring on to here is only and only protected by a copyright. And that is how the earlier form of industrial property got converted into an intellectual property. Now, what is an industrial property? As we can see on to the industrial property can be taken into the format of how we are taking on to and how we'll be taking that particular thing into take it. Now, industrial property describes physical matter that is the product of an idea or the concept or commercial purposes as well. Now, the industrial property, as I can define, is nothing but into the physical matter as well. This is a product of an idea or a concept for the commercial purposes. I'll be very clear. These are the definitions that was laid down earlier, but as the time elapsed and thankfully to TRIPS in 1996, when the TRIPS got confined, it not only classified between the industrial property and the copyright, but all brought together, bringing into the intellectual property rights. Also, the protection were given a universal space that whether it's a violation in US or it's a violation in India, it would be considered as a violation. The protection tenure was given a particular time period. Now, how are they protected? They are protected. I'm talking specifically here about the industrial property. Industrial property are protected either by patent in the form of a patent objects. And earlier, it was merely the idea of an idea or a concept to be taken on. Now, there was also a question which in India recently, or not call it recently, but in 2005 got a very much clarity that a patent can be granted of two things. Number one, it is granted over a product or a process or a combination of a product or process. Second is by the trademarks. Who is branding that particular project? And thankfully to TRIPS, when they have brought in India in 1999, we came out with the Trademarks Act. Prior to 1999, and before I move prior to 1999, this was again thankfully to the TRIPS that made possible in 1996 when India signed the trade-related aspects of intellectual property rights. This led to a foundation on India for including the merchandise marks and the service marks and well-known trademarks all under one umbrella by the name of trademarks. So as you can see, the idea behind getting TRIPS was such predetermined and such calculative that they didn't want excessive of things to be covered simultaneously at different places. They take an idea of bringing all under one umbrella, number one. Number two, bringing it all in such a sophisticated packets that it should not be multiplicity. It should all those aligned together shall be brought in. Prior situation in India, prior to 1999, prior to the Trademarks Act of 1999, India had an act for the protection of trademarks in the form of Trademarks and Merchandise Marks Act. Trade and Merchandise Marks Act. Now, when this Trade and Merchandise Marks Act was there, it lacked service marks. It lacked well-known trademarks. And then after India India being a signatory to TRIPS, in the year 1999, by the purview of Article 51C of the Indian Constitution, India had to realign and sign the trade related aspects and repealed the Trade and Merchandise Marks Act and brought the Trademarks Act of 1999. And this Trademarks Act of 1999 was not a single feature. It also included, it was a very exhaustive law. It also marked, defined, and included trade marks, merchandise marks, service marks. I'll tell you in detail what exactly is meant by service marks in my next couple of slides. Third was the industrial designs. Industrial design, as the word itself is suggesting, these are the designs which are used in the industries. So this can be in the form of the blueprints of the machines, the structures of the machines, the big ones, smaller ones, or if, for example, machines, irrespective of which type of machine it is. The only thing is it shall require an industrial approach. Now, let me classify it here. It also includes a machine which is used in the farm and the form of a pulley to take water out from a well, to a wheel which is required in a big machine established at the BHEL for the manufacturing of a turbine plant. The next is a trade secret, and that is how a trade is kept. The best example that comes to my mind is, again, being food lover, is either Coca-Cola, which is the combination is still a trade secret. The batter of KFC's chicken, which is still kept in Kentucky in one of the banks. Layout designs. Layout designs are nothing but how a design is being protected. And this includes majorly in the cars, and much more talked about. This was the major point of contention between Apple and Samsung. This is a major point of contention between major companies of how the design should be taken. And last but not the least comes the geographical indications. The geographical indications are the form of the industrial property, which is, out of all what we have studied, there are only 2 of them. Out of the 7 forms of intellectual property, there are only 2, which is not given to one single person, but it is a group right. One is geographical indication, and the second one is the farmer's right. Geographical indication is something that and I'll cite a couple of very generous examples which my lovely audience here would tackle and understand easily. Now, geographical indications are the rights which a person or a group of persons have got because that particular property was from that particular area. There was a recent dispute for such things as well. That dispute was the Rasgulla. The Rasgulla between the West Bengal and Odisha. The Banarsi sari, the Kanjivaram silk, the Bagh print, the Chanderi silk, the Assam tea, the Gorakhpur terracotta. These are few examples that I recently cited were or are the best examples of how we are taking up the geographical indications in our country as well. I would appreciate the present government that since 2014, and as we are entering the 2023, the increase in the number of geographical indications in terms of percentage is 79%, and many more to come in the years ahead. What advantage do we get with that particular thing is not only in the terms of money or economy or finances, but also the reputation in the market. Today, the value of original Kanjivaram silk or a Banarsi sari not only in India, but abroad is huge. And that is how. There are only 2 major countries whose teas have been very prominent. One is Sri Lanka by Ceylon teas, or the Assam tea, or the Darjeeling or the Assam tea that we are referring on to. Now, what are the major types of intellectual property right? The major types of intellectual property right that we see are in the forms, and this we are dividing in the form or the major usme, is the functional and the technical inventions that are covered nothing but by the Patents Act. This Patent Act is nothing but the Patents Act of 1970, and two major amendments that we see today is in the year 1999 and 2005. The reason why I'm mentioning the amendments being taking place was post 1996 or majorly after that. And these are very important because that is how India not only got a new law in the form of Trademarks Act, but it also got a major of thing in the format, or they aligned their present or existing laws according to the TRIPS. Now, where there is involved with a functional and a technical invention, we'll go for the Patents Act. When it is pure literary or an artistic work, we'll go for a Copyright Act. And where there is a symbol, a logo, or a brand, we'll all go for the Trademarks Act of 1999 in our country. Now, this particular cartoon, this is always brought, and whether it's my class in an undergraduate course or a post-graduation course, whether this I have also included as one of the pictures in my dissertation when I was referring on to. Now, this picture on your screen shows that all I asked was that can I patent my copyrighted trade? Now, these two persons on your screen sitting on the right side and the person who's banging his head. This person banging his head on the left side is or can be a student of IPR who has learned or who might be practicing as well IPR in a form of an IPR office. Because for a work and for someone who has been a student of IPR would always know that if there is this product in my hand, which is in a form of a pen, or something like the lenses that I'm wearing, all these particular things have or can have only one form of a protection. I've never said that this pen cannot have a copyright. But what I'm trying to say that the function or other things, for example, this pen, the function of this pen and having a clipper and a gel technology in the nib or something like that, it can be a fountain pen or something, is a patented technology. The words or the brand of which this pen belonged to would be the trademark. And the things written in the form that this is this, is nothing but a copyrighted work. And that is where now this question by the client, all I ask, can I patent my copyrighted trademark? No, nobody can patent a copyrighted trademark. But yes, simultaneously, a product can have a patent, a trademark, or a copyright. I'm also reminded by an anecdote given to me by my teacher, who I owe my intellectual property rights knowledge and learning, is that he always used to say that whenever you wake up in the morning and till the time you go to the bed, you are surrounded by intellectual property rights. And this I can say even so confidently today that when I see the participants, which are more than 65, all of us today, the first thing that we meet is not our spouses or not our relatives or not our family, not our mobile even. We meet the intellectual property rights. And the best example today is what I'm citing is a mobile phone. A mobile phone is nothing but a bundle of rights. It starts with a brand. It can be Apple, it can be Samsung, it can be MI, it can be whatever you think of. All these brands that I took the name of are the trademarks, the trademark holders. The technology inside the mobile is a patented technology. And the algorithm or the software or the operating system, we generally popularly call it as OS, is a copyrighted work. Now, moving particularly to each of the intellectual property rights that we see, this is how patents is. Patents, and believe me, if I'll come or if I'll be ever asked what is your favorite format or what is how you're taking on to, I would never say that one or the format is is my favorite, or which I only consider to be a form of an intellectual property rights. Intellectual property rights, and specifically when I reach on to the patents. In India, the patent is covered under the Patents Act of 1970, which is predominantly amended by the Patents Act of 2005, Patent Amendment Act of 2005. And this is that year and this Amendment Act that I'm referring on to, or I referred in 10 minutes back itself. Now, this act extends to the whole of India. Yes, it cannot extend outside India, but there are few provisions to which we call as the evergreening of patents or the green patent, something. But it comes with a particular knowledge and particular provisions that we'll have to take care of. Generally, intellectual property rights are taken only and only how the particular provisions have been taken onto. The Patent Act in India is governing or converting or intellectually conversioning the product and process, or product or process. What is patent? Patent is described as an invention for which an inventor claims an exclusive right. I'll repeat. Patent is something which is described as an invention for which the inventor claims the exclusive right. How could a patenter or inventor can claim an exclusive right? By creating that particular product or by creating a process on which the product works. Invention patentable. Number one, it should be new. It should be useful. It should be not obvious. It should pertain to the patentable subject matter. I'll repeat. It should be new or novel. I generally disagreed with this particular word. And the only reason was that if it is an invention, it obviously have to be a new one. Because if it is not a new one, you can't include it in the domain of the invention. But then it comes that it's better that what is there. But the answer comes all inventions. I'll repeat, all patents and all inventions. There are two different words. All patents are inventions, but all inventions are not worth patenting. This is what the statement is. All patents are inventions, but not all inventions are worth being patented. The point that I'm trying to tell, that if a patent is granted, it has to be an invention. But out of all the inventions, not all inventions are worth being patented. So anything which is new or novel. How do we define the term new or novel? Anything which was not known to the public at large, or something of which you were not aware of. This brings me to the 2 points. Whether and can a discovery be a subject matter of invention, be a subject matter of patent? And there I answer. My answer here is that not at all. A discovery and an invention, as for coming for the subject matter of patent, it is only and only the invention and not the discovery. And I am still wondering why my audience is not asking me the difference between the two. But for the sake of my audience, I'll explain this difference as well. Discoveries is, or what it means. Discovery means that something which is existing and which is not known to the mankind. And one fine day, somebody finds it. For example, the relics of Mohenjo-daro, the relics of Indus Valley civilization. I'll invite everybody to Bhopal, place where I personally am settled for now past nearly 17, 18 odd years. And there is this place nearby Bhopal called as Bhimbetka or Bhojpur Temple. The Bhimbetka here, as what I was telling, is a place where you can see more than 3,000 years. There are certain caricatures being drawn by our forefathers. After carbon dating, they came out to be the date to be more than 3,000 years ago. It's before Christ. Now, what I'm trying to tell you out here is that has been there. But when it was discovered in the 1970s, I will say early 80s. Can that be patented? The answer is no. Why? We all forget the first word. Patent is nothing but an intellectual property right. What was the intellect behind it? Nothing. The intellect behind that has to be there. The human intellect needs to be applied. Second, it needs to be useful. We just, one fine day, cannot make anything which has got no usage. Believe me, you cannot patent it. And for your sake, I'll share the link to how a patent form looks like. You will get to know this. That you'll have to mention the usage of your product or process there. I'll cite one very wonderful example which each one of us knows very well. That is the RO and the UV. I'm using these two patented technologies in a reference to the glass of water we drink. And this I can tell you even after sipping that particular water. Now, the water that I sipped is a product of a process of purification. I guess we all remember the first purification that we had in our houses. Yes, I'm referring on to the hand pumps, or many of us who also still have a well in their places. No, I was talking about something else. I was talking about the filters. If you remember the filters that we had, that steel one, majorly the steel one, which had two particular tubes. And in the upper side of that particular filter, you need to put the water, it would come drop by drop by drop to the second portion where we had a tap and we used to drink that. From there, the first and the foremost of the filter plants that we saw was the AquaGuard. The AquaGuard had two parallel cylinders. One was filled every time when the person used to come. We as kids were so excited to see that there are small carbon particles that are being taken on to in that particular area. Not only that, we also saw that how from there we moved towards a technology which today saw the RO and the UV technology. The RO and the UV technology is something that the first came was an RO. RO stands for reverse osmosis. Reverse osmosis is a technology that was using to filter the water. And then with that RO, they combined the UV, that was the ultraviolet. Now, earlier when the RO came, it was a patented technology. And then when the UV came, it combined RO plus UV. And that is where the third and very important thing came, that it was not obvious. Nobody ever thought of mixing the two. The first person that brought RO and UV together increase its subjectivity, increase its usefulness. That yes, this is very useful. Useful for whom? Useful for mankind. And that is, you need to prove. In the application form, you need to mention its usefulness. And when we mention the usefulness, and the board who is examining, the examination team at the patents office, when they examine it, that it is a useful thing, then only they grant it. And then comes the last point, that is, it should be pertaining to use of the subject matter. Patentable subject matter, for that factor, we have seen the Patents Act. The Patents Act of 1970, Section 3, Section 4 are two sections, which is just after the definition clause. Section 1 is short title, extent, commencement. Section 2 comes with the definition clause, where invention is defined, inventable step is defined, usefulness is defined, capable of industrial application is defined, and has an economic viability. Economic viability, that somebody who's making it should also use it. Patentable subject matter, Section 3 and Section 4 says what cannot be an invention, or an invention which cannot be patented. Section 3 has a list of total of 21 such subjects. A mathematical formula cannot be patented. A thing that can be utilized for medicinal purposes shall not be patented. An area, music thing, literary work cannot be patented. A human genome cannot be patented. No. Section 4, anything which is in relation to defense or atom or the atomic energy cannot be patented. And these two sections only in the entire Patents Act of 1970 prohibits what cannot be the subject matter worth patenting. They never say that it cannot be an invention. It can be. And that is that invention which cannot be patented. The patentable subject matter is something that we need to see more time in a day. Now, what is a patentable subject matter? First and foremost, it needs to be an invention. It relates to a process or a product, or both product or a process. It involves an inventive step. There should be something that intellect should be there. And as soon as I put in my intellect, it has to be an inventive step. Inventive step is something which was not thought of. Prior to that, we were purifying my water by boiling the water, then filtering it with that silk cloth, putting it into the filter. RO, UV, plus RO, plus UV, plus TDS. These are what? These are inventive steps. And it shall be capable of an industrial application. Capable of industrial application means that it must apply. It must work. An invention is no invention if it is not working. Imagine you got a smartphone which has a touch screen, which has now a touch earphone, but it's not working. Would it be useful for you? No. I have this specs. This comes with a technology with it protects you from the blue rays, which is coming from your laptop screens, computer screens, iPhones, anything. And one fine day it stops working. This particular specs for me would be of no usage, because now the application is nothing. What is the life and duration of the patent? The life of a patent, or the term of a patent, is 20 years from the date of filing of all the inventions. The priority date is first to file. First to file means whosoever, like for example, I, along with a couple of more people, thought of the same idea, same thing. But the first one to file among us would be granted, or the first to file on his would be granted with the priority date. Always remember that 20 days starts from the date of filing and not from the date of grant. The date of patent is the date of filing the application for the patent. The term of the patent is counted from this date. Reason why it is done so. Believe me, guys, when I say that I'm a law student, I'm a student from IPR, I would have a reasoning behind everything in this world. Anything, and it's not particularly confining myself to the intellectual property, but anything on which today in India we have a law, you would have a reasoning first. That's the reason why you are having a law. The reasoning behind that why the date of filing should be taken into consideration and not the date of award is because when you see the application process and the examination process, it is uploaded on the website. And when it is uploaded on the website, this is how we take it. This is how we classify it. And this is how it is open to the world at large, so that anyone who comes out with an objection to the same shall be known. So it's not only about the objection. One can file only the objection when he can read the entire thing. And once that knowledge or that invention is in public, anyone can copy it. And that is the reason why date of filing of the application is taken into consideration. What is the fees of filing of patent? In India, the fees for filing of patent application is 750 rupees for individuals and 3,000 rupees for legal entities. Now, when I use the term legal entities, I mean artificial persons. I mean the persons who got their existence through law. And through law, that is why they are legal entities. For example, partnership firm. For example, a company. For example, a society. For example, any of the limited liability partnership firms. Any NGO. There is no fees for the first and second year. But there is a renewable fees to be paid on yearly basis is required to be paid from 3rd to the 20th year for keeping the patent in force. The patent lapses if the renewal fees is not paid within the prescribed time. What is the prescribed time? This is mentioned before the year expires 15 days. Now, is a patent granted in one country and can be enforceable in the other country? No. And for now, there is nothing called as a global patent or a world patent. But yes, this was one of the lacunas which was being affected, and there were so many cases. And that is why they came out with an idea of green patenting or evergreening of patent. Granting of a patent, as I said, can only be done through law, and law is made by a country which has its applicability only in its country and not outside it. There might be a common things, like for example, killing of a person is called as murder. Murder is punishable in IPC and is defined in IPC. 299 is 300 is where murder is defined. 302 is where murder is punished. But a murder committed outside India by a non-Indian, IPC doesn't have its jurisdiction there. A murder committed inside the territory of India, IPC comes into force. You can book a person, file an FIR, trial will be there, prosecution, everything can be done. But a murder committed outside, no. Same thing applies to the intellectual property rights as well. Infringement done outside India for a patent in India, jurisdiction, there's no jurisdiction. And that is where institutions, the first institution, the foremost, I use the word guarding, preservation, protection is done by the World Intellectual Property Rights Organization. Refusal of the patent in one country does not mean that it will be terminated in all the countries. Number of examples I can cite right now. Something that was not patented in India is a valid patent in Germany, it's a valid patent in UK, and it's a valid patent in USA. I would also like to bring the Lanham's Act, the Act of the United States of America, the protection for the patents particularly. And look how I would not say that they are very wicked in that. I would say they are clever. I would say they are witty. I would say they are very clever when it comes for the rights of the nation. I'll tell you why. In India, the term new means that it should not be known to any person except you, any person in your own country or at the world at large. I am clear, I guess. It should not be known to you or any person at world at large. But the Lamb-Hands Act says it should not be known to any person within the territory of United States of America. What does that provide? That, for example, you go outside, learn a technology, come back to US, get it applied, get the product, process, or both, you will get a patent granted in the United States of America. But don't you think that's a violation of a term called as new? Because new never says, new never comes with an answer that this is a territory where new cannot happen. But what has that done? That has provided a boost in the number of patents filed by United States of America. People from US, agencies in US send their employees to the other states when I mean outside United States of America, to different countries, learn some good things which is not patented in US, bring that technology to US, patent it there and take it ahead. Job done. They also come out with an answer. When we don't have a jurisdiction, how can we control? Therefore, our definition would only have a jurisdiction of the land and nothing else. So once it is refused, once it is not granted, does not takes away your right that this cannot be granted by any other country. United States under the Lamb-Hands Act has done this provision yet again and has refused to amend the definition. The patent holders in India, the list of top 10 patent holders in India comprises only in the pharmaceutical and the biotech companies. And this is a chart which is available on the IP India, and this is the government chart that I'm referring to. Now, when I talk about that, the list of the top 10 patent holders, either biotech or the pharmaceutical companies, I mean that the patent after the 2005 amendment, where the process was also allowed. I'll give you one small example what I'm referring on. We all have, and specifically during the last 2 years, known what is the importance of medicines like Dolo. And also what is the importance of medicines like generic medicines. We all have come across with these terms yet again. If I'll ask you today, I'm feeling a bit feverish, there is slight body pain. I guess even here, I can see many of the doctors or the PhDs who have already, I'm not talking to these doctors, I'm referring on to the MBBS or the ND doctor. The first thing that we come to our mind, but without going to the doctor, is take a paracetamol. But nowadays, we do not say, nowadays we have started taking paracetamol, but the first thing that are crocin or have a crocin tablet. Why? Because that is a product, that is a trademark that was there. And through the process, each company today, Cipla, PG, you name it, they are coming out with their paracetamols. Have you ever wondered why? You see a tablet like Cinarest, or you see a tablet like Dolo again, or you see, I'll name one which I hated the most in my childhood days, 7Cs, the cod liver oil yellow tablets. Now in the market, if you're not seeing 7Cs, but you will see a yellow color tablet, which is exactly the cod liver oil. Now, post 2005, when the process and the product of both were allowed, this led maximum patent to the biotech or the pharmaceutical companies. In India, 184 patents are held by the Council of Scientific and Industrial Research, that is CSIR, a government agency, which is based itself. You can see the name, Council of Scientific and Industrial Research. इनका काम ही है research करना, training करना, किस पर? Scientific or industry. Followed by Ranbaxy, which is a world brand known. You'll also study a wonderful case on Ranbaxy in India for the IPRs. While the top 10 patent holders across the world are IT companies, in India, no IT firm have the patents. But that's where the amendments and that's where the awareness of the IP mechanisms and other things have been created, so that the IPRs can be taken into place. Here on your screen is the world's youngest patent holder, and unfortunately, he's on a wheelchair. But I would say, fortunately, he was on a wheelchair, but he never let that thing to stop him, but he utilized that thing. This photo is of Indian Stephen Hawking. I'm talking about Hrideshwar Singh Bhati. He is from Jaipur. He's a 9-year-old boy. Now he turned 10. He has invented a game of 6 players playing a circular chess. Generally, a chess game is played between 2 players only. No grouping and other things done. And what he has designed is a 6-player chess. And this design is already patented to his name. So you might have seen that when he was 9 and that patent was granted to him, age barrier would never come for you to be a patent. Language barrier would never come. Educational background would never come. What do you expect from a 9-year-old boy? He would have done his PhDs, he's done his master's, he's gone to university. And this is the beauty of the. What do you think, that he would be illiterate? No, he won't. He might also not have a voter ID card or a driving license. And yet he has a patent to his name. Does that also classify, if I have one patent, can I do not have another? No. We all have seen the wonderful story in the movie 3 Idiots. And we have in India such people who alone have nearly 50, 100 patents to their name and credits. This is what a patent office certificate looks like. This is the US patent that we are seeing on your screen. Next in line is the Trademarks Act. But before I move to the Trademarks Act, I would request any of my audience, if they have got any question to take, please feel free to write on patent so that we can move smoothly towards the trademarks. You will please use the chat box, or if you can unmute yourself and ask your question.
Good evening, ma'am.
Hello. Yes, Dakshita ma'am, please take your question.
Ma'am, could you please repeat what you said about the date of patenting and the time of the 20 days you just mentioned? Could you just repeat that?
I didn't say 20 days, it's 20 years thing. And for every 20 years, then that comes to the public area. I was referring on to the 20 days thing that you were referring on to. I said about was the renewal fees that it needs to be paid. So that is generally paid every year that it ends. You'll have to pay a renewal fees. That is what I was referring on to, ma'am.
Hello, sir.
Ma'am, could you please speak a bit louder?
Hello, sir.
Yes, ma'am.
Am I audible, sir?
Yes, ma'am, you are.
Okay, sir. Sir, I just want some clarification regarding the sui generis application.
Yes, ma'am.
How it is applicable in patent that I need after the TRIPS agreement.
Yes, ma'am.
when this sui generis has been established and it has been came into the fact, and how it is applicability on the patent, just I want to some clarification
Yeah.
regarding this.
Ma'am, for the sui generis system, this is one of those particular system that have the TRIPS specifically mentioned.
Yes.
Unfortunately, Indian Patents Act do not has still taken on the ground of the sui generis application. But one thing that I need to tell, which is there in the slide as well. So when I will be dealing the TRIPS era in my presentation later, I'll explain how and what the sui generis system is all about. So it is not particularly limiting to the patents, but the trademark and copyright, and it was an application system that
Okay.
was required. It has been adopted by a couple of countries. Lanham Act refers to the sui generis system of US. Unfortunately, till date, Indian legal and Indian IP regime has not yet broadly or legalized the sui generis system. So that is one of those particular answers. But in particularly to your question, when we move later to our presentation, I'll deal with the sui generis system as well.
Okay, then. Thank you, sir.
I can see the chat box as well, where there is a question by Purv Mathur. It's described that there are not universal patent law. I would not say that there is no universal patent law, and as to what the previous question would also there, TRIPS provides a universality. But as we all know, we are sovereign nations. And if I'll talk about India, particularly India itself is a sovereign nation. Our constitution provides that. Article 51C provides also that if we or if India signs any international covenant, treaty, convention, so the municipal laws shall also be in aligning to that particular provision. So by the 51C, we get a major of the amendments after signing the treaty, or we can get an entire new legislation as well. Please share the patents official website link. I'll definitely do that. Not only the patent thing, but we would share the entire that how an IP India now they have come out with a new platform, which is also one of the expected and the accepted model, that in one website you can get the link to all the government filings. They've also allowed with the online filings as well. Then why we follow, then why we follows US patent? We do not follow the US patent law, sir. Even I'll tell you one thing very clearly, there is no country that we follow for any of the regime. It is the TRIPS, and that brought for the first time the universality. So it is US also following the TRIPS, India also following the TRIPS, and rather than using a word following, I would say that this is what the TRIPS have mandated, so that their entire world should have a universalization. Universalization would also come in the tenure. So if somebody says copyright is for 60 years plus the author's lifetime, so that is something common across the world. If any patent registered in US and if any person doesn't follow, then why the case lodged against him? I'm sorry, if any patent is registered in US and if any person don't follow that, why the case law? Sir, if I'm taking your question correctly, like for example, any patent which is registered in US and somebody who's not following. Now, I'll tell you one thing, it's not about following. It's only about the infringement, and that infringement should be brought to the notice of the patent holder. For example, if the patent holder doesn't know it and an infringement is being carried on, this cannot be stopped. When we move to the trademarks, we'll take that thing also into consideration, that how the infringement is taking on. If any patent is registered in US, the other person registered the same as patent in India. Is it? No, sir, it's not possible. It is not possible because Indian laws are very clear. And that is where when a patent application is submitted at the patent office, the examination team, the patent agents which are appointed, the examination team's duty is that they examine. They also keep it on the open for the public to give their objections, raise their objections. And on the basis of the entire process of examination, they grant or they would reject the application, or they would also allow for certain amendments in the application. I hope, Apu sir, I have answered that query. So with no more questions ahead with it, I'll take the trademarks. Now, trademark is covered under the act called as the Trademarks Act 1999. This came into force on September 15th, 2003. It replaced the Trade and Mercantile Mark Act of 1958. It extends to the whole of India. Now, the trademark is what? It is a symbol, a logo, word, sound, color, design, or other device that is used to identify a business or a product in commerce, and it differentiates from mine to yours. Simple. So we might have seen the logos, we might have seen anything, and I'm surrounded by many of the trademarks available in front of me right now. Now, the trademarks are of the particular perspective that we see. They can be of different symbols for representing a trademark as well. These are TM, SM, and R. Now, what's the difference between the three? TM stands for a trademark, and it is intent to use that application is filed for the product. SM is used for the services. Now, what is the difference between a trademark and a service mark? That we'll see ahead. And the word it says that when you are using that mark for trading, by selling, buying something, is a trade. When it's only for extension of services, this would come. Best is hotel industry, the hospitality industries, so far and so forth. And then this R comes. These are at the stage of applications, the TMs and the SMs. And once it is registered, you'll find a circular R or a capital R in bold written inside a circle. What is the registration process? First is an application for the search, then the application for the registration. Application for search means you find, like for example, if my name is Dr. Devanshu and I want that D something written in that particular point, I'll have to see whether that D is not resembling the math D ka D. I should see that the D should not represent the diesel wala D. That is called as application for search. So we come with an answer. Either it's a yes or it's a no. If it is a yes, I cannot move to the next stage of registration. If it is a no, then only I can move for the application of the registration. Once my application is filed, then happens the examination of not mine, examination of my application by the agents there. Then as soon as that is done, it is open for advertisement to the public at large. That this person is with this business, wants to register this trademark. If anyone has any opposition, they can file the opposition. And then also comes a two-stage. First is if that application is filed, the opposition that is filed for opposition resembles any of the trademark, patent would not be granted. If it is not resembling, certificate for trademark shall be issued and the person can start doing the business by that name. Duration and fees of trademark. Also, before I move, ideally from this stage to this stage, you can use the words like TM and SM. Not at this stage. A trademark is valid for 10 years from the date of application. This is one of those intellectual property rights which can be renewed again and again and again, till the time the trademark holder wants it. Trademark is valid only for 10 years from the date of application again, which may be renewed further for 10 years on the payment of fees. So 10 years is the basic time, then further renewed for 10 years. What happened at the end of the 20 years? You can further renew it for 10 years. How many times that circle can go? Unlimited number of times that circle can go. Service marks are reserved exclusively for the owners for 17 years and it can also be renewed. What is the fees? The government fees is 2,500 for each class of goods and services. What is this class of goods? Food, industries, right? So they have number of classes under the Trademarks Act from where they can take that. The application for the usage of the trademark. A trademark is a sign used on or in connection with the marketing of the goods or services. It is used on the goods means that it may appear not only on goods themselves, but on the container or the wrapper in which the goods are when the goods are sold. Now, what is set apart from what being an underlying text? Now, correct usage is Raymond Textile is India's leading producer of worsted suiting fabric with over 60% of market share. What is an incorrect use? Raymond Textiles, India's leading producer of the worsted suiting fabric with over 60% of market share. Now, what's the difference between them? I guess the line till here is absolutely same. What's the major difference? Both of these are exactly the same thing that you have written. The difference that I'll like to tell you is in the next line. What are the specific size, font, and everything? This is registered, registered, registered. Incorrect is this. I'll give you examples as well. We all have seen the parachute bottle of the coconut oil, the blue bottle with a parachute made, which has a coconut tree and a parachute written there. Remember? That represents the coconut oil. And see in the market, any part of the country you are. With my experience, I can tell you this. You'll find that blue bottle, either the parachute spelling would have an S in it, or a double O in spite of a U. But the bottle size, shape, everything remains the same. Same thing as Adidas. I have seen Eddie Bass written. Now go to the local market, you find the t-shirts and everything written Adidas on it. They are nothing but an infringement. So you might be thinking why an action has not been taken. And that is what Apur sir, when he asked me the question regarding the patents, I posed that down. That it should be brought to the notice of the infringement to the holder in case of patents, in case of trademarks. And he's the only one who can take action on it, nobody else. Why? Because that property belongs to that person. Spelling, as you have seen, Calvin Klein, Tommy Hilfiger, MPC Potteries, Gwalior. Now see the spelling. So these are small of the things. Now trademarks. See, the name, the logo type, symbol, slogan, shape, color. Beautification of this Coca-Cola bottle, purposefully kept here. This bottle design is also protected. And that is why you'll never see a Pepsi bottle or a common with that of the Coca-Cola bottle. How that C is written. The beautification of the Coca-Cola logo is the C. The two C's that represent are both written in a different fonts. while the O and A, which all are also repeated, are exactly written the same way. Now, I'll show you the logo here of McDonald's. I guess each one of us know this logo. This M is a registered trademark. This logo behind it, I'm loving it, is also a registered trademark. Any doubts, any questions on trademark before we move ahead?
Anyone who needs to ask any question, you can unmute yourself and ask your question. Oh,
Yeah, please go ahead.
Sir, could you explain the meaning of R again?
R is a registered trademark, ma'am. So, yeah, I'm coming to that point. So this is where the application is at the filing stage, and this R can only be used once the trademark is registered and you have the certificate of registration. I hope I've cleared that question. So if they have any other questions on patent or trademark, please feel free to use the chat box. I would, once we complete with the copyright, I'll take over those particulars doubts as well. Now, the Indian Copyright Act is a 1957 act. It has been amended now majorly by 5 times, majorly in the 1999, that again an amendment, as I've told, after the TRIPS. So 82, 84, 92, 94, and then comes a major part of 1999. Now, what is the meaning of copyright? Copyright, before I define it the legal way which has been given by the statute, I will try to define it. It never means the right to copy. Why? Because it is a right which one can give. Anything which is made original is original. And as soon as and that's why in patent, you find a patentee. In trademark, you find trademark holder. In copyright, you'll find the word author. Author is the person who owns the copyright. On author, do not just misinterpret yourself that it's only defining to the book, the poem, or something. Author here is even for the case of a painter who has been granted as a copyright. Copyright means it is a right which grants the protection to the unique expression of ideas. And this is, believe me, one area which in the intellectual property rights is beautiful. Beautiful in all format. I have said this in n number of times in my classes. Now, for example, it was 1st January 2023. Or let's take an example of 4 friends, A, B, C, and D. A, B, C, and D. A had a DSLR camera in his hand. B had a mobile phone in his hand. C had this paintbrush and a canvas in his possession. And D had a crayon and a drawing sheet with him. And all 4 gathered at the same place, the top of the hill, to capture the first sunrise of the year 2023. Same place, 4 different people, 4 different apparatuses. And what they have to capture? The common sight of the rising sun. The end product, a beautiful picture clicked by A from his camera. Second, a beautiful picture clicked by B in his mobile phone. C, a wonderful drawing made by C. a beautiful carved cryonic picture of the same sun that rised on 1st of January 2023. The beauty of this act, the beauty of this intellectual property right, all four would have a separate copyright of the same thing. And that is why it is called as, it is the protection of the unique expression of the idea. All my friends out here, any part of our life, either in morning, lunch, dinner, whatever, we eat chapatis, we eat roti, we call it by fulka, call it by whatever name you want to call it. But that flour, generally a wheat flour, made in company. I'm not talking about the shape. I'm not talking about the size. I'm not talking about the length, breadth or something. I'm just talking about the gold fulka that we are referring to. Each house prepares it. Believe me, each one of them. And I do not know. When I was a kid, I used to be there with my mother in the kitchen. And we used to make different shapes, birds, ducks, this and that. That was also mother's way of making us eat more of it. The flour remains the same. Let's imagine we bought it also from the same thing. We got Ashirwad atta, all of us. But the roti would be a different thing. I'll tell you one more example. Each of us who owns a house or who are in a rented house, we put a nameplate outside our houses. Let's go and see it today. Like, it can be a lithograph or something that a stone and carved on the stones. Nowadays, asbestos sheets or the PVCs. Nowadays, new of it, the LED lights are there on your boards and other things. All of it are copyrighted works. What needs to be copyrighted is the only one word, that is original. Through copyright, I'll teach you one lesson. Be original in your life. Don't be a copy of anyone else. Then only you can be copyrighted. Then only you'll have a value. Be original. Original in copyright is defined wonderfully. It says the term original in copyright means that the work originated from the author. Originated from the author. That's it. Now, somebody can ask me, sir, originated from the author can also be like, I went without taking anybody's name. A music director of India went to US, heard a music, came back, copied that, made a song in India. Can that be copyrighted? Answer is yes. He can file the infringement suit that tunes are copied. But when it was added with the lyrics, with the performed on a new set of actor and actresses, I know I'm hinting a question to everybody. And I know as soon as I'll end this slide and I'll ask any questions on copyright, the first question that will be popped up, sir, what happens in the case of remixes of a song? I'll come to that. Or I'll try to cover that so that that question doesn't arise on to. Is that an original work? Yes. And why I'm saying this? A very important saying for copyright. Copyright cannot protect the idea, but expression of an idea. Now come back to the example that I gave. The first sunrise of 2023. What was the idea? To capture the sunrise of 1st January 2023. Sun is the same. The rising point is the same. People standing at the point was same. But the out product, I can't say what was copied. Or then the first author comes, ki nahi, sabse pehle we click the picture from a DLSR or the click from the mobile. Whichever would be the first will give the copyright only to that person. Rest others would be the copy work. No. And this is what is originated by the author means. Idea was common, but the expression of idea is copyrighted. Roti, same place, same flour, everything. But yes, the shapes and other things would differ. There is no requirement of novelty or uniqueness as there is in patent law. Nothing. Nowadays, I do not know how many of you have visited the modern art galleries or something. See, Many times you put that picture, put it upside down, put it this way, that way. You're unable to identify what is there in that picture. But then to your shock, it comes, the painting is worth 25 lakh rupees. The modern art. Something it might not be that can be perceived by you. That is something in a very simple way I'll try to understand. Like, for example, I don't know German language. Okay, now a German book is given to me. It is immaterial whether I know it or not. The person who wrote it is a copyrighted work. Okay. I translated it. I know the question can come, sir, is Gita a copyrighted work? The Bhagavad Gita I'm referring to. I come from a city which has its popularity knowingly, unknowingly, I guess, to the major part of the world. Each of us, if we are Hindu by religion and we have a puja ghar in our houses, we would have a book printed and published from the Gita Press, Gorakhpur. Can they claim a copyright on Bhagavad Gita? Nobody can. But expression, how wonderfully they have crafted that book. Book is a copyrighted work. Printed form, that is copyrighted. All books are copyrighted. All books. ISBN. All are copyrighted. Copyright law protects the expression of an idea and not the idea itself. A wonderful saying, and my friends here who have been a law students would understand the idea expression dichotomy. I'm referring on to R.G. Anand versus Deluxe Films. Idea expression dichotomy. Now, what is covered by copyright? Literally, any form of book. This includes the book that you give to your children. A for apple, B for ball, that apple made, that aeroplane made. I studied A for apple, B for ball, C for cat, D for dog. And the new generation today studies A for aeroplane, B for badminton. Yes. Idea remains the same. What is the idea? To teach, to learn. Expression of an idea differs. Films. Film is what? Covering of everything. I don't know how many of my friends are there from Hyderabad, or they have been to a place there in Hyderabad called as the Ramoji Film City. And if you by any chance attend the first of a thing, a picture is not made by an actor or an actress. A picture is not made by a musician. A picture is not made by the lyricist. And that is where the answer comes. Who owns a copyright in a film? And that question I'm posing that question open till the time we are having this question answer. I'll discuss the answer in the session itself. Third, dramatic. And there dramatic, I'm talking about the school dramas, say laker, the national level drama. Musical, artistic, and the sound recording. I'll add algorithms, I'll add softwares, everything. Softwares are copyrighted in India. Always remember that. What is not covered by copyright? Ideas, facts, recipes. There has been this case, the recipe of butter chicken, and there have been a huge debate. I've been nearly to 7 of such restaurants in New Delhi who claims that they were the originators of the butter chicken. Again, nobody. Works lacking originality. Like, for example, I don't know nowadays if there is there or not, but the telephone directory used to be issued by the BSNL or the MTNL. Go to metropolitans, I've seen that yellow pages. No, those things are not thing, but you cannot copyright that. The names, titles, or the short phrases, it cannot be copyrighted. What is the registration process? The registrar of a copyright is completing by a simple application form with the appropriate fees. need not send a copy of your work. It may appear with the same title, but if each work has been created independently, each will have its own copyright protection. Each of it. Like, for example, if I'm a poet and I'm writing one poem, it's a copyright. I wrote 15 poems. All 15 are separate copyrighted works. I compiled my 100 poems into a book. A book has a separate copyright. This compilation of 100 poems have a separate copyright. What is the duration of the copyright? The duration, this is as per TRIPS. In Indian laws, this is 60 years. Because TRIPS give you a leverage of minimum word. Wahan minimum likha hai. It's author lifetime plus 50 years according to TRIPS. For Indian, it is all same. It is author's lifetime plus 60 years. So for example, if a producer is there, for example, an artist is there who drew a painting, it will continue till his lifetime. And then the day when he dies, from that day till 60 years. There's only one exception till date I came across with. And that is Gitanjali, written by Sri Rabindranath Tagore. And why I'll say this is also not an exception if I get into the very technical side of it. He was one person who never thought of his own self. So when he wrote Gitanjali, a book, beautiful book. If I've not read it, please read it. This is my urge to you all. That book has been copyrighted on the name of Shantiniketan. And yes, that is also possible. NGOs can also go for it. Publication houses can also own the copyrights. And believe me, major of the books today are owned by the publication houses. So, what did Rabindranath Tagore did? His famous work, Gitanjali, is copyrighted to Shantiniketan. Now comes a catch. When will Shantiniketan die? The answer is never. And that is why, even after the death of Rabindranath Tagore, even the passing of 60 years of the death of Rabindranath Tagore, the copyright on Gitanjali is still continuing and getting royalty to Shantiniketan. What is a fair usage? Now, this is where it's very important. That I told na ki it's not only about the infringement, but also about the usage, the fair usage that we study. Now, fair usage gives the permission to use the copyrighted material in certain criteria are met. For example, parallelly, if people were using it. But for example, I was writing a poem, and I can give you an example. I wrote a poem called as कोशिश करने वालों की कभी हार नहीं होती. Now, before I said that, anyone from the audience said, how can you write a poem on that? This is already written by Shri Harivansh Rai Bachchan ji. Are you violating? Are you copied that particular thing? Yes, I infringed by even copying the title, in spite if the poem has something else written in it. The entire poem of mine. But even if I borrowed the title, I violated the copyright. As if I've told him the permission that I only want to borrow the title and the rest of the poem would be different. Then it wouldn't happen. Fair usage goes that I was sitting here in Bhopal, my friend sitting in Prayagraj, we are writing a poem, or we tried to build across, like movie's name. And then the fair usage comes, no, he had a different thought, he had a different thought. There is something indifferent to that, and that can be done. It protects the freedom of speech and expression of both the authors, one sitting in Bhopal, one sitting in Prayagraj. It promotes public benefits like education. There have been many cases. If you want to read, there is this wonderful case, type on Google, you'll find Delhi photocopies case, where entire book was photocopied and circulated to the students outside Delhi University. Violation. Violation. But, for example, if it is used for teaching purposes in the classroom by the teacher to the student only, without involving economic, the teacher should not charge a penny for that. Not violation, exception, fair usage. Beware of this usage to be an excuse. And this has been done. It never assumes that you use your falls under the fair usage. Saving money is not sufficient excuse. Laziness can be a trap. Believe me. Not everything would fall under the fair. You have to prove your fair. It's a defense. It's a defense. Always remember that. How much of that can I be used? And this depends. It is a factual thing. What I've jotted down is because of the certain judgments, because of certain things. And it is also a factual. For example, if Devanshu sir has written up to 5 works from one author, up to 10% over 15 works, no. This is a one factual condition that derived from one case law. If you did that and somebody claims and this is there, you might land into trouble as well, because this is again a factual situation. It is not a precedent that I'm reciting out. Always take action against infringement, always. What constitutes infringement? Let's see that. And also I'll tell you the purpose of keeping this S differently or in a next line. If it is an infringement against you, you will take it. But if it is an infringement in multiplicity, also not done to you, but somebody else's copyrighted work, do claim it. Because if we respect the IPR of the other persons, we would also respect our intellectual property right would also be respected by the world. Now, what constitutes infringement is any reproduction, usage, distribution, performance of the work without the permission of the author. See, any identical or the substantial with similar reproduction is also covered. Infringement, damages, injunction. I'll tell you one more thing. Specifically in the academic phrase, there is something called as plagiarism. And this is, again, nothing but a violation of the copyright. You are not giving due credit to the author. Even you are giving due credit, but you are taking verbatim, exact, identical, substantial, you're gone. It is under the plagiarism. What are the remedies? A suit can lie in the district of the High Court. The court may issue an injunction or to either to prevent or the infringer to take and thing. Also to pay the royalties. Not only that, destroy the work which were copyright infringement. These are certain types of, and pilot orders can also be given. Apple sued HTC over iPhone patents. These are now the cases that we'll be referring on to. So HTC was a Taiwanese company and the patent was claimed by Apple. This is also an answer which Apu sir asked us as well. Remedies for trademark infringement. A suit can lie in district of the High Courts. Punishment may extend to 6 months or 3 years. Permanent ban on engaging in commercial activities with the same name and the same class of products. There is a maximum punishment of infringement. Example of successful civil enforcement actions against trademark. Look, this Adidas thing that I was referring on to. The stickers, the things that have been taken, pasted, printed, sold in the local market. I was traveling in train a couple of months back. There was this vendor who enters the compartment and says, and unfortunately for us, it was against the rules. Second AC, if a vendor is coming, but okay, let's go. And he was selling that. This is Adidas wallet made from original leather and was sold in the market nearby Mathura Junction. Number one, Adidas never manufactures the wallets. Number two, so that was a product. Again, who can take an action against it? The Adidas company or the members from there. But we can be vigilant, calling the police and saying that this is a non-copyrighted product which is being sold in the name of a copyright owner. So just to clear those particular things. Fake products are the examples of the same. Many a times nowadays, even on the online websites as well, you see the fake products being there. 3 suits filed by Adidas Salomon AG in the Delhi High Court against counterfeiters. At the initial stage, infringing goods were seized by the local commissioners. Cases were decreed recently and a damage of 15 lakh was awarded to the Adidas Solomon Company. Now, for the copyright infringement, suit can be filed in district court and high court under 63 of the Act. Punishment up to 3 years and fine as per the claims. My friends from academics, if you are booked for a copyright infringement, believe me, you'll be in a bigger trouble. And as per the new UGC norms, I guess that is, we all have read around. So please do not involve yourself. It's an urge, it's a plea. Do not involve yourself into anti-plagiarism activities. Some of the copyright infringements I like to show it to you. Ritika Limited versus Ashwini Kumar. See the originals. On your left is the original. On your right is the copied version. Ritika Limited again versus Neena Talukdar. Ritika Limited versus Sajid Mobin. Now, these things have been copyrighted, registered. And the cases have been gained. The non-copyrighted product was confiscated and destroyed. They were also asked to pay the accounts of profit. What is accounts of profit and how it differs from the other format of giving damages? Accounts of profit means by selling the confiscated or the non-copyrighted work, how much profit this company has made shall be returned to the original owner. That's it. Now, innocent infringements. Sir, I never knew that this is copyrighted. Kahin likha hi nahi tha C uske upar. Occurs when the infringer was unaware that the things were protected. No excuse if the work is properly displayed. Likha hua, it's a patented product, or the trademark symbols are there, the copyright thing is there. Now, the best way is this itself. Like, for example, Dev Saris, and they have a copyright sign to it and the year. Why this year? But again, you should know. 60 years. Or lifetime plus 60 years. So you know from where to calculate it on. What happens if the time period elapses? Patent, trademark, copyright, whatever, not renewed. Can anybody use it? The answer is yes, it is open to public at large. Anybody can use it. Therefore, to conclude, it creates yourself rather than using others' creation. Be original. That's one thing where I will always be advocating of. Do not use competitors' mark in such a way that it harms the competitor in an unfair way. And no comparisons that are likely to cause confusions. Never. And this I'm urging because I can see potential IPR holders here. Now, I'll introduce myself. I'm basically a law faculty. Entering my 12th and 13th year of teaching. Did my PhD in intellectual property rights. I have written nearly to my name. There are at least 29 journals, all either UGC or Scopus indexed. But one thing that I also want to enhance and show it more, and it's not that I want to give about my own self or boasting about my own self, but to clear a myth. And the myth is that today at this date, I have 2 patents on my name. Now, the point which I'm trying to tell is that being a law teacher or law academician, can I apply for patents? The answer is a yes. And I have 3 copyrights to my name. So this is the point which I'm trying to tell, that even in the field of academics, nobody can be prohibited to get this thing done. And that is how what I'm trying to prove you again and again for this factor. So this would be all from my end. A wonderful line that has always inspired me is a technological advancement made the job of the creator easy. It also made the job of the copier easy. Read that thing again, and you'll understand what I exactly want to present it out here. That it took me 3.5 months to write a paper, and it took only 3.5 seconds by pressing Ctrl+C and Ctrl+V for you to replicate it or to copy that part. So don't do that. Do not get involved into such things, and then do not take it. This was all from my end. Thank you. Any questions to anyone?
Any questions from the participants?
Suppose I'm the author of any book that contains university exam question in it. Further, another author also includes that question. That is a violation of copyright. The answer is, till the time you are selling that particular book for economic advancement, you have done a violation. If that question is used, I'll expand your question, Apu sir. If that question is used in my examination system, for example, I'm a teacher, I was making a question paper for my students of 60 batch. I went to the website, I opened the question papers of various other universities. They took one question each from 10 such universities, made my 10 question in the question paper and gave it to the students. Have I violated? Answer is no. Why? Nothing economically has been hampered. But if I am putting that thing that now what I've done, compiled this 10, put it in a book, sold question bank on this subject in the market for 20 rupees, violation has been done. So, Apu sir, I hope that answers the question there.
Any other question? Participants?
Thank you very much, sir, for this very comprehensive presentation. I could not see the PPT because I'm blind, but I really enjoyed your presentation. I'll be happy if you could share with us your patent, 2 patents. Thank you.
Dakshita ma'am, thank you. I would take it as a compliment that even if the PPT was not visible, I was much more audible to take it ahead. The patent that I have, believe me, is one that we have been designing as a teaching model. Specifically during the specifically during the COVID times, we developed this particular model of teaching. And I am very happy to share that the second of the patent that we, along with my colleagues here, we have taken which is helping not only the blind students, but also the one who are by any grace of God, because we have always been believing of the fact that if God takes yours one senses, he'll always bless you with the another one. So looking for that thing that helped us to maintain something. So this was the second model of teaching, which is a model which somewhere is also hinted in the NEP. Now, why we were more proud in saying that we registered or we filed for the patent in 2020 July, till the time when the national education policy was not even known to people. And when 2020, when we see the national education policy coming into existence and hints of our patent the model was reflective. I'll say hint, I'm not saying the entire thing was reflected. Hint of them was reflected in the various parts of the national education policy of 2020. We feel that yes, what we were trying to suggest and to develop, we were the first ones to be granted. That patent got granted in 2022 itself. It took 2.5 years for us to get that particular patent. And both are the models that is be taken. Coming to the copyright that I'm sharing on to, copyright is basically on the poem and a compilation of the book poem that I've written on to. So that is one of the areas. Not only that, whenever or many of my friends or people who are writing books want to claim a copyright, have a word with the publisher to claim a copyright as well. Now, one question that I said really that what happens or who owns a copyright in case of, so let me just discuss it very quickly. In case of a painting, whichever mode you are using onto, the painting is always the one who has painted it. The copyright is owned by that person. In case of an author, book, poem, prose, poetry, whatever it is, it's always the one who has written it. Now, question comes translations. So translations are permissions. Okay, permissions taken by one person to the other. That is how the case goes. Is what an answer? The one who has translated it with due permission of the original author. The copyright is with the one who has translated it. Music. So always the music director. Always. Question comes in case of a movie film. It can be. And do not go whether it's a 10-second movie, 2-hour movie, 3-hour movie, 1-hour movie, 10 minutes movie, whatever it is. In case of a movie, it is always the, anyone who would like to attempt it? In case of a movie, the copyright is owned by
the producer.
The producer. Any specific reason for that? As I said, law always goes for a reason.
Because he's funded everything.
He's funded everyone. Because everybody was giving their services and their services was already paid. And that's the reason why the producer of a cinematograph film, that's the word which is used in the copyright, is used. Wonderful. Now, next set of questions. Anyone who, in the case of a software program, it is always software developer who is again being paid. So it's generally the company who is paying its officials are taking for that particular point. Okay. Now, in case, and there is this wonderful case, do read it. This is called as the monkey selfie case. So wonderful, wonderful case. So this happens, there is this photographer who went to a rainforest to click his photo. Then a couple of animals chases him. He runs, his phone, his camera gets dropped. This camera was picked up by a monkey who, in spite, doesn't know how to use it, but he takes that DSLR with the lens towards him and clicks a photograph of his own. And that photo appears that of that monkey to be smiling. Fine. And then he comes back in search of his camera. He takes the camera and he was like getting late for his flight. He took the camera, took the flight, went to his home. And there he saw this photo. What he does, he took the print of the photo, sells it, that this is the point. PETA, that is the animal rights organization, they claim that this picture, and he also writes a story that this has happened, this picture was clicked by him. And all royalty was being paid to the camera person. Now the question comes in this case. I know the decision as well, but I'm openly posing for my audience. Who in this case shall get the copyright? I'll just give you a hint. Monkey would not get a copyright ever, according to any law in any country. But PETA filed a case against it that we are the ones who are protecting the animal rights. Therefore, as an organization, we should get the copyright. The
photographer.
Very good. That was also the question, because the one who owns the camera, he said that because it is my camera, I should get the copyright. Saptrishi sir says that the camera brand should get a copyright. Okay, wonderful new addition to the point. Now I'll ask this question to Saptrishi sir itself. If I'm correct, it's Saptrishi sir or ma'am, I'm not sure, but yeah. Now my address to this is, like, for example, I have, I guess we all would have. So I have this phone of Samsung Fold 4. I take a photo from this beautiful camera. Who would own the copyright? Or let's take another example, which was a very remarkable feature. Something that we were part of it. The 2 years back, the COVID times, such sessions were very common. And what we were asked, you'll have to take a screenshot to prove your attendance. Am I correct? And we used to take a screenshot either from our laptops or from our phones and to submit it to our authorities. Now my question, did the Droid Pinel group owns the copyright? Because they were the one who organized, they are the one, their Zoom is being used and everything. Or Saptrishi sir, Anjali ma'am, Sujay sir, Dakshita ma'am, or myself, we clicked photos from our phones or screenshots on our laptops. Each of the photo has a copyright. Or can the Samsung, MI, Dell, HP, they were claiming the copyright?
I think the people who are organizing the event, that Zoom session, would be the ones who do it.
But
because the camera is only a tool in the hand, like a brush in the hand of a painter.
Sujay sir, wonderful answer, but I'm now posing that. When I asked the first question about the cinematograph film, why did you people say that the producers should get? Because the producer has paid everybody. Don't you think, Sujay sir, you have paid the registration fees? And therefore, the photo clicked by Sujay sir in his mobile, it should be the copyright of Sujay sir and not Devanshu and not Droid Pinel Group. And yes, the answer is photo clicked by Sujay sir has his copyright. Photo clicked by Anjali ma'am has her copyright. Photo clicked by Devanshu has his copyright, and the entire recording on YouTube is the copyright of the Droid Pinel Group. And now coming to the moot question that I asked, in case of this monkey selfie case, who should get it? The answer, again, the court has decided it. And I still feel that the IPR should also, at no point it is called to be the human intellectual property. But yes, capturing of it was being clicked, but yes, the camera was owned by a particular person, and that photo was taken into an answer. That is the reason why the camera person owns the copyright in that particular case. With this, I would end my thing. Any questions, any suggestions, any comment or compliment, feel free to say it here. It was a wonderful session. I would thank Droid Pinel Group for inviting me. I would thank my lovely audience and my fellow people out here who was such a wonderful audience to make this session very interactive. And it's always a pleasure, whether Gaurav sir calls me, and now seeing Gauri ma'am there, I guess that's a wonderful sign always to be there. So thank you so much, guys, and thank you, everybody.
There are compliments for you in the chat box.
Not about compliments, it's all about how well these people have taken that session. So I couldn't have been a wonderful presenter if the audience wouldn't have been such a wonderful one, and the host as well. So all compliments to all the other people, the 65 on the screen except me, for making this session a wonderful one. So joint compliments to the entire team.
Thank you so much, sir. Actually, it was a very wonderful and insightful session. So thank you so much for sparing a precious time for us and the participants. And I think the participants are showing their love for you on the chat box.
Thank you so much. Anyone who needs to or to need to connect to me can contact the organizers. They have my email ID, they have my phone number. In case you require this PPT, I'll be more than happy. I make all the PPTs new, so any case. But whenever you use it, do give me the due credits for the copyright of the presentations as well. As you will find, if I'll send you the PPT, I'll give you the copyrights for the bottle that I took, or the thank you logo, everything you'll find in my PPT, that this picture was taken from there, this picture was taken from there, because this is how we respect the IPR of others. And this is also how our IPRs get being respected. Yes, ma'am, I have, Rituja ma'am, I have nearly 150 cases on IPR. Such cases, yes, there are many. There is one which I have not discussed, was the, I'm so sorry, Gauri ma'am, I'm continuing even after saying a thank you for that. Yeah, but there is this wonderful case. If you really want to study monkey selfie, please read it. It's there on the Google. And it's a real case. There is another real case where an auto Uber driver was outside from the road, get on the footpath, accident happens. Who has to be liable in that case as well? So that is also an IDR case. Do read that case. Well, there are so many. There is RG Anand versus Deluxe Films, Indian case. Believe me, you'll understand that why they say that idea cannot be copyrighted. It's only the expression of an idea. RG Anand versus Deluxe Films. Wonderful case. Wonderful case. There is an Indian case on remixes and the copies being made. So we also saw Agnipath, the old one with Amitabh Bachchan and the new one with Hrithik Roshan. Who had the rights? What all things are there? Such things are wonderfully explained. So surely, Rituja ma'am, I guess we
Sir,
can.
may I ask you a question?
Yes, sir, please, sir.
Yeah, sir, we have our favorite composer, Bappi Lahiri.
Yeah.
Am I audible?
Yes, so just say you're audible.
Yeah. Okay. We have the late composer who has used the music of the West time and time again, and he used to say that if you take music from more than 3 beats or 3 beats, is not an infringement of copyright.
True, sir.
Until now, there has been no case which is very found guilty.
Okay. Okay, so just sir, if I guess I have taken the question correctly, it's not only about Bapida. It is, I can name n numbers of music directors, composers who have taken that thing.
Anu Malik and so many of them.
Yeah. It's not like who's topping the chart as well. So even an infringement by one or the number of them. I'll tell you one thing.
Yeah.
And the plea that has always been given for the same is that what is music? And this is discussed at the Supreme Court. What is music? Music is nothing but only 7 sur. Okay. So whichever instrument we play, it's only the 7 sur, sa, re, ga, ma, pa. Now, n numbers of permutation and combinations makes that particular music on that particular point. Now, how a 3 minutes, and that's where I stated this thing when I was discussing copyright. It's not about how am I taking one particular beat and using it and mixing it in a 3.5 minute song. There is a word in copyright, specifically in copyright, which is a legal fair usage word called as adaptation. And that adaptation, I'll tell you, sir, very, very clearly, I'll tell you. So just sir, favorite actor of yours?
Mel Gibson.
Sir, Mel Gibson.
Yeah.
Yeah. Now, you went to a movie, or you have, I'm pretty sure you have those classics with you. And then you see Mel Gibson wearing a leather jacket, black, and a shades, the aviators there. You go to the market.
Yeah.
You go to the market. You buy the exact same aviators, you buy the same black leather jacket, pose yourself in the mirror, just looking like Mel Gibson. Yeah. Now, is this a violation of copyright? The answer is no. I'll tell you, the answer is no. I'm telling you, very legally, I'm telling you the answer is no. The answer is that yes, you are adapting. Now, if I'll take it, so which car do you drive? And the color as well.
I have a Corolla.
And which color it is?
Champagne gold.
Champagne gold. Now, your neighbor buys same champagne gold and says it on your face. So, Joy, sir, your car looked outstandingly well, and therefore I bought it. Can you file an infringement copyright against him?
No.
And that is where adaptation comes into place. And I guess now I've answered your query. If you're talking about that, Sujay sir, I can give you a number of things. One more. I'm so sorry, and I'm interrupting between. You were only talking about certain of the music by Bapida or by ex music director. I can show you movies.
Yeah, absolutely.
Forget about scripts, sir. Even the poster of the movies are copied. And I'll take one step more ahead. Forget about the poster, the name of the movie. And the movie name is There is a Hollywood movie called as The Body, and the copy of that movie is the Jism movie done in Jism tha. And see the poster, sir. See the poster. Same pose by the actor and the actress. Same black sheet. Body in Hindi is Jism. Same storyline. Same everything. The reason they got saved, again, territoriality of the copyright. You can only protect the copyright in the country.
Okay.
And not in your own country.
Okay.
These are case laws. These are recent case laws that I'm referring on to and there are so many. But I can talk the entire 3 months only on copyright.
True, sir. Thank you so much.
Thank you so much, Sujay, sir.
Very insightful. Thank you.
Yes, sir. Please drive safely, sir. Gauri ma'am, over to you. I guess no more questions will be there.
No, sir. Actually, it is a very interesting session. Even I haven't developed my interest. So, any more questions from the participants?
Good evening, sir. I had one question.
Yes, sir.
Yeah. So my question is regarding what question like Sujoy sir had also put up. So my question is regarding the remakes and the remakes which are being made regarding the various songs. So some of the songs which we had heard like when we were young, and the same song has been remade now with a different version, with a different actor, and with a different whoever may be. So I understand that maybe because of since the same, let's say like T-Series is holding the ownership of that song, so they are remaking. So still, sir, won't it be like infringement of any such kind of rights, because the ones who had sung in the originals are the ones who are completely different from the ones who are singing the new ones, the new version. True. So won't it affect the copyright issue? So that is my question.
Okay. So one thing again, forget about T-Series, forget about anybody else. Let's say, sir, you and me, okay? We have it. You sang the original version of it. It's your right now. And that is where I said at the starting, copyright was never right to copy, but it was a right for the author to give it to copy. Okay. And the reason why I'm telling you this, Abhi, recently we had this Sri Lankan song, a very famous one. Anyone who can hint where I'm going on to. So this was recently replicated in Hindi as well with the Hindi lyrics. I'm referring on to the Sri Lankan song, the Mati Mige Wala song. Okay? Now this has now been incorporated in a movie. Two things are there. Number one, if it is from the same house, as what Sirs mentioned, Saptarishi said that number one, is it from the same house? Same house means same music composition house. So T-Series has a T-Series song. Okay? Then again, it's my right. I produced it way back. And that is where now I'll tell you, there is this Guild Producers Society. And people like, I'll name a person as well. He's Mr. Javed Akhtar. So when he was the member of parliament from the Rajya Sabha, he brought this thing that it should not only be the right of the producer. We should also have shares in it. Also, what happens that why he said that we should have share in it, because he said that if a song gets hit, it's because of my lyrics. It's because of the lyrics of Gulzar Sahab or Javed Akhtar ji that the movie got hit. I know major of you would disagree with. We watch a song because Shah Rukh Khan was there. I might be using an outdated actor, but okay. Or we watch the song because Deepika Padukone was there. But the reason what I'm trying to tell that nowadays, even these actors have started buying royalty in the producer. That, okay, my fees is 1 crore rupees for the movie. I'll charge that. But if your movie gets hit, and that is why I'll tell you guys, you'll find major of the actors in our country are now moving towards the producer side. Is only because of the factor of getting royalty. Now, one part is that same publication house, he can reproduce that work how many times? N number of times. Adding remixes, putting remixes, doing whatever they feel like. I guess this also might have been felt by you people, although I'm not using Insta, I'm not using Snapchats or anything. But has any one of you felt that you used a song in any of your posts and within 7 days you get a notice from Instagram that you cannot, we are turning down this video because it's a copyright violation?
True, sir. True.
Now, this is where T-Series research team is at its best. They raise a question even at the YouTube that if my YouTube channel has their song in it, they have turned down. I'll give you one case. T-Series had even sent a notice via YouTube to the person who was playing on his terrace. He was performing certain acts of his dance. And the song was played at the back, not at his terrace, but it was played at the terrace of the other person. T-Series sent a notice that how can you play that song in your own video? And that video had nearly 1,000 something likes to that. The person had to turn down his video. So this is their creative thing that nobody else can use it. Second comes is, and please read this. I have read a book which is on T-Series. T-Series we all knew was owned by Gulshan Kumar. They were the first in the industry to bring these music videos. And they, not only that, all the bhajans that we heard, Anuradha Podwalji and everything, was done by T-Series itself. And then when he was shot dead, his son took over the business and he only played a copyright. The present music production house that I can say very confidently has a member of more than 250 copywriters with them. This is one case. Second case, if T-Series video has to be sold or taken by somebody else. This happens in this Sri Lankan video. Now, if I and Saptrishi sir jointly comes out and we made something as in the music thing, which is a boom, like we have created a sensation. Music industries would come to us. We are going to buy this song of yours. And this happened in the Sri Lankan case. Read that case as well. They say, we are ready to buy it. And then the singers pose the condition, which if you're going to translate it in Hindi, use the entire tune, but we want to be the singers of that song, even in your Bollywood movie. Now, this is again a contract between Saptrishi sir and me. Also, for example, I and Saptrishi sir jointly produced a music. And then at a later stage, we tried to go apart. Ki I'll have my own production house, you'll have your own production house. What about the thing? Now, the owner says that it should be the copyright of the author. Now there are two. What would happen in that case? There, the agreement takes place. A contract takes place. And what is the rule of our country? Anything which is agreed between in personam, there are two things, right in personam, right in rem. Right in personam between us. Like for example, Saptrishi sir, or I'll take Sujoy sir again. Sujoy sir is ready to sell his Corona champagne gold to me for ₹500. Is this, he said. Now, any one of you can say, how can you do that? But what I and Sujoy sir would say, it's in a contract between us. He is ready to sell it to me for ₹500. I am ready to buy it in ₹500. Nobody else should have a problem. That is right in personam. And what is right in rem? He has put it on sale. My car is on sale. Anyone who will bid for the higher price, I'll sell it. This is right in rem. Right for the world at large. Now, if one person has agreed to sell his original song for remix purpose, for whatever purpose, the absolute entire rights, it is between that particular persons who are entering into an agreement, nothing else. So yes, we see remixes happening. We scratch our head. How is this possible? Or what a worth or worthless thing has been created. But it is between, it is in lakhs and crores, sir, which is beyond us. But that can be sold only by the person who has originally created it. And that also goes for literature. For example, if I wrote a book and Droid Pinel Group asked me, sir, IPR, but you have written a wonderful book. Please sell your royalty to us. Please sell it to me. I'll give you an example. All those my friends who are law graduates or law students here. There is a wonderful book on constitutional law of India, which is called as V.N. Shukla on Constitution. You would be astonished to know that V.N. Shukla sir wrote that book and he sold the royalty to that book for an ambassador car at that time and ₹1 lakh. and the publishers of that book still continues his name even after his death. And open that book cover page, after the cover page, the page, it says edited by some other person. But what is the name of the book? V.N. Shukla's Constitutional Law of India. So this is how IPR is being used. So this is how I would answer, and this is how what I have to produce on the question of remixes and other things that comes into play.
Thank you so much, sir.
Okay, sir. Any other question? Finally, I guess, Gauri ma'am, we can build now. So I'm still in university, sir. Yeah, I was loving this session. I never knew when it is 6:30. But yeah, my email ID, please write to me if you have got anything on IPR. I generally respond within 48 hours on my mails. So that is the maximum time I would take. So thank you so much.
Thank you so much, sir. And thank you to all the participants. See you all tomorrow at 4 p.m. again with another workshop. Thank you, sir. Thank you so much.
Gauri ma'am, thank you, everybody.